landmark constitutional court ruling on dual citizenship, a turning point for South Africans abroad. Welcome to the Bold African Voice, BAV, your trusted platform for in-depth analysis of Africa's most pressing political, legal, and social issues. I'm Abdul Karim Kargbo, born and raised in Africa. Today, we bring you a landmark ruling from South Africa that could reshape how Africa defines citizenship. What happens when a law takes your nationality away without notice? And what does it mean when the highest court steps in to restore it? Stay with us as we dive into the human impact, legal transformation, and continental significance of this pivotal judgment. Because here at BAV, we don't just report Africa's stories, we dissect them, challenge them, and reimagine a bolder continent. A long-awaited justice for South Africans in the diaspora. In a landmark ruling that reverberates far beyond the courtroom, the Constitutional Court of South Africa has struck down a controversial provision of the South African Citizenship Act of 1995, which had automatically stripped South Africans of their citizenship if they acquired that of another country without ministerial approval. The court declared the provision unconstitutional ab initio, invalid from the day it came into effect in October 1995, and restored the citizenship status of all affected individuals retroactively. This judgment not only rectifies a historical legislative oversight, but also sets a powerful legal precedent for citizenship rights in Africa and globally. The implications of this decision are deeply significant, touching on identity, democratic participation, mobility, and the constitutional principle of fairness. The case, from personal tragedy to public victory. The legal challenge was initiated by the Democratic Alliance, DA, South Africa's main opposition party, following growing concern from citizens abroad who discovered they had unknowingly lost their nationality. One such individual was Philip Platjes, a chartered accountant born in Cape Town, who lost his citizenship after acquiring British nationality through marriage. As detailed in the Constitutional Court judgment authored by Justice Stephen Majate, Constitutional Court Judgment 2024, Platjes' ordeal was emblematic of a systemic flaw. After naturalizing in the UK in 2007, he only learned of his citizenship loss 7 years later when he attempted to renew his South African passport. His documents were returned marked cancelled, effectively severing his legal ties to his country of birth without due process or even notification. Legal rationale: citizenship is a fundamental right. Justice: Majate's reasoning is pivotal in reshaping the conversation on citizenship in constitutional democracies. He emphasized, loss of citizenship has severe consequences. It entails being deemed a foreigner. Where the law automatically terminates citizenship without any forewarning and even knowledge, simply on account of dual citizenship, that is plainly a deprivation of citizenship. This underscores the principle that citizenship is not a privilege to be arbitrarily revoked, but a right embedded in the foundational values of human dignity, equality, and freedom, as guaranteed by Section 20 of the South African Constitution. The court also denounced the vagueness of the act, which granted the Minister of Home Affairs unrestrained discretion to approve or deny dual citizenship requests without clear criteria or accountability. This violated both the rule of law and administrative justice, failing to meet constitutional thresholds. Comparative insights: Africa's complex terrain on dual citizenship. South Africa's reversal marks a progressive shift in Africa, a continent where dual citizenship laws remain fragmented and often politically charged. Nigeria and Ghana recognize dual nationality but impose political limitations, such as barring dual citizens from certain public offices. Yet, they do not automatically revoke citizenship for acquiring a second nationality. Kenya, following its 2010 constitutional reforms, now allows dual citizenship and has reinstated citizenship for those previously affected by older laws. Eritrea and Tanzania continue to reject dual nationality entirely, fearing disloyalty or divided allegiance. Zimbabwe flip-flopped for years, only in 2013 passing a new constitution that formally allowed dual citizenship by birth, but left gray areas for naturalized citizens. What sets South Africa's case apart is its judicial activism in correcting an injustice retroactively and restoring citizenship rights to those affected since 1995. This is uncommon in African jurisprudence and represents a progressive, rights-based approach to constitutional interpretation. Political, economic, and social implications for South Africa. The ruling carries significant forward-looking ramifications. 1. Political participation. South Africans abroad who lost their citizenship can now vote, run for office, and engage in nation-building activities. This is a win for diaspora democracy. 2. Economic linkages, restoring citizenship to diaspora. South Africans boost investment flows, remittances, and skills repatriation, aligning with government efforts to attract global South African talent. 3. Social justice. For many, citizenship is an anchor of identity and belonging. The judgment reaffirms their emotional and legal ties to the nation, healing psychological wounds inflicted by arbitrary legal disenfranchisement. Critique of state conduct and policy failure. The ruling also casts a harsh light on the Department of Home Affairs, which not only defended the flawed law, but failed to proactively review its constitutionality over nearly 3 decades. Why did successive ministers of Home Affairs, both from the African National Congress, ANC, and other political parties, not initiate reform earlier? Why were there no comprehensive audits to identify and assist affected citizens before they were denied passports, benefits, and access? This negligence reveals bureaucratic inertia and a lack of political will to prioritize citizens' rights over administrative convenience. Reclaiming identity, the South African diaspora, and the citizenship renaissance. The Constitutional Court's ruling has rekindled a sense of identity among thousands of South Africans in the diaspora who were relegated to the shadows of statelessness or quasi-foreign status. The judgment is not just a legal correction, it is a cultural and emotional restoration for those who never cease to identify as South African, regardless of their passports. For many, like Philip Plotches, South Africa was not just a country of origin, but an emotional homeland. His statement that losing his passport was one of the saddest days in his life echoes a sentiment shared by countless others, whose lives and loyalties transcended borders, yet were punished for that very global presence. This moment is also symbolic of post-apartheid constitutional maturity, where once the state denied citizenship based on race and class, today's constitutional democracy is showing signs of prioritizing inclusivity, dignity, and due process, even if it comes decades late. Pan-African citizenship laws towards continental legal harmonization, the ruling begs a broader continental question. Should African states harmonize dual citizenship laws under a common legal framework or protocol? Intra-African migration and diaspora remittances are core components of the African Union's Agenda 2063, particularly under flagship project number 2, the African Passport and Free Movement of People. Yet, domestic laws on nationality remain inconsistent, often undermining the AU's own objectives. Some regional legal frameworks exist, such as the ECOWAS Protocol on Free Movement, but they stop short of tackling dual nationality. In contrast, the European Union, despite national variations, permits multi-citizenship in nearly all its member states, reinforcing European identity and integration. South Africa's Constitutional Court may have inadvertently triggered an opportunity for the African Court on Human and People's Rights, AFCHPR, and the African Commission to develop a model protocol or set of guidelines for dual nationality recognition. The principles of non-discrimination, procedural fairness, and political inclusion that underpin this judgment could serve as a legal template continent-wide. Diaspora engagement and policy opportunities. With the door reopened for affected South Africans, the state must now pivot toward reparative policy action. Several critical steps should be taken. 1. Automatic reinstatement and outreach. The Department of Home Affairs should launch an international outreach campaign to identify, contact, and reinstate all individuals who lost their citizenship under the unconstitutional provision, without requiring cumbersome reapplication procedures. 2. Legal and administrative reform. Parliament must amend the South African Citizenship Act to eliminate ambiguity and establish a rights-based framework for dual citizenship, ensuring no future recurrence. 3. Diaspora investment and rights programs. With citizenship restored, South Africa should expand diaspora engagement policies, including property ownership rights, voting access, pension portability, and national service opportunities for returning citizens. 4. Digital citizenship portals, leveraging technology. A digital identity verification and rights portal can assist South Africans abroad in securely managing their documents, accessing services, and voting remotely. Unanswered questions and legal complexities. Despite the clarity of the ruling, several unresolved legal and policy questions remain. Restitution or compensation. Will affected individuals who lost jobs, property rights, or other opportunities due to their revoked citizenship be entitled to compensation? Children born. During the gap. What of children born to affected South Africans during the period of citizenship loss? Are they also retroactively deemed citizens by descent? Security screening. In light of global security concerns, how will South Africa balance restored citizenship rights with enhanced vetting of re-entry and dual nationality registrations? Moreover, borderline legal cases, such as those involving renunciation for security clearance or asylum purposes, may require individual adjudication to assess intent and context. Broader democratic implications. Citizenship as a human right. In declaring citizenship loss without forewarning as a deprivation, the Constitutional Court has deepened South Africa's commitment to the doctrine of substantive constitutionalism. It acknowledges that the right to belong cannot be arbitrarily taken away, not by bureaucratic default, nor by the discretion of a minister unbound by legislative criteria. This aligns with global jurisprudence, including the Inter-American Court of Human Rights and the European Court of Human Rights, both of which have ruled in multiple cases that citizenship revocation must meet tests of necessity, proportionality, and due process. South Africa's decision now sits prominently among these rulings, adding to global best practices in the field of nationality law. A wake-up call for other African governments. The implications of this ruling extend beyond Pretoria. Across Africa, millions of citizens face ambiguous or punitive citizenship laws that disenfranchise dual nationals, descendants born abroad, or returnees from the diaspora. In Ethiopia, recent political shifts have made dual nationals targets of suspicion, particularly during periods of unrest. In Uganda, citizenship revocation has at times been used as a political weapon, particularly against opposition figures or critics living abroad. In Cameroon, diaspora Cameroonians have been barred from voting or acquiring property, despite being a major source of remittances. The South African case sends a clear message. Africa cannot afford to alienate its diaspora through outdated legal frameworks. As migration and dual identity become the norm, not the exception, countries must embrace flexible and human rights compliant laws to avoid legal backlash and reputational damage. The role of civil society and political accountability in defending constitutional rights. One of the most underappreciated elements of this landmark case is the instrumental role played by civil society and opposition parties, particularly the Democratic Alliance, DA, in initiating and sustaining the legal challenge that culminated in the Constitutional Court's ruling. Despite losing initially in the Pretoria High Court, the DA persisted through the judicial hierarchy, appealing to the Supreme Court of Appeal, SCA, and ultimately to the Constitutional Court for confirmation of the SCA's ruling. This perseverance highlights a crucial check and balance mechanism in South Africa's constitutional democracy, where political actors can play a constructive role in defending civil liberties and upholding the rule of law. The judgment should serve as a case study for opposition parties across Africa. Legislative oversight and judicial recourse are not merely tools for political point scoring, but are essential pillars of democratic accountability. Far too often, African opposition parties neglect court based strategies for challenging unconstitutional laws, relying instead on street protests or political negotiations, which are more vulnerable to repression or co optation. Civil society organizations, particularly legal advocacy groups such as Section 27, Freedom Under Law, and Lawyers for Human Rights in South Africa, have historically played similar roles in holding the state accountable. Going forward, a coordinated campaign by diaspora rights organizations, constitutional lawyers, and political parties could ensure that citizenship rights are fully restored and protected, including pressure for legislative amendments. Implications for African diaspora, enfranchisement, and the right to return. At the heart of this judgment lies a broader and more profound issue: the right to return home. For African citizens living abroad, often for work, education, safety, or love, losing citizenship means losing the right to return to one's country without restriction, participate in national affairs, inherit property, or even be buried on ancestral land. The South African ruling, by re-anchoring citizenship in constitutional dignity and identity, reaffirms that no state should force its citizens to choose between national belonging and global opportunity. Across Africa, the political enfranchisement of the diaspora remains piecemeal and inconsistent. Ghana and Nigeria allow voting from abroad, but implementation is logistically limited and excludes many eligible voters due to registration inefficiencies. Zimbabwe and Tanzania prohibit diaspora voting altogether, reinforcing a false dichotomy between physical presence and civic legitimacy. Senegal has been more progressive, with diaspora electoral constituencies and legislative representation. South Africa now has the opportunity, and arguably the obligation, to expand its diaspora enfranchisement mechanisms, ensuring that every citizen, regardless of location, can vote in national elections, run for public office, and fully participate in democratic life. This includes revisiting restrictive residency requirements for electoral participation and embracing digital platforms for secure registration and e-voting. A wake-up call for bureaucratic reform and human rights sensitization. The Department of Home Affairs, DHA, must now confront the deeper institutional failures that allowed this unconstitutional provision to persist unchecked for nearly 3 decades. This is not simply a legal issue, it's an indictment of a bureaucratic culture that often privileges procedure over people. Key reforms needed include: 1. Audit and notification systems. Establish a comprehensive digital tracking and alert system to notify citizens of potential citizenship impacts when applying for foreign nationality or making legal status changes abroad. 2. Training and sensitization. DHA officials both domestically and in consulates, must undergo mandatory training on constitutional rights, due process, and the limits of administrative discretion. 3. Transparent discretionary powers. If the minister is to retain any discretionary role over dual citizenship, it must be clearly defined, procedurally fair, and subject to oversight, with written reasons for every decision. 4. Review of other discretion based laws. South Africa must conduct a broader legislative audit of all laws where ministerial discretion can affect constitutional rights. Citizenship is only one domain among many where unchecked executive authority remains a threat. This systemic introspection is vital not only for preventing future rights violations, but also for restoring public confidence in state institutions, especially among the diaspora whose trust may have been eroded. Connecting the judgment to broader African integration goals. This judgment also comes at a critical time when Pan-African institutions, notably the African Union, AU, are advancing plans to enhance continental integration through mobility, trade, and identity harmonization. The AU's Free Movement Protocol, adopted in 2018 but still awaiting widespread ratification, aims to facilitate visa-free travel, residency rights, and mutual recognition of credentials across member states. South Africa's ruling implicitly supports the spirit of that protocol, even if dual citizenship was not explicitly addressed. By affirming the constitutional centrality of identity, belonging, and legal status, the court has laid a potential foundation for future harmonized citizenship laws across Africa. As the African Continental Free Trade Area, AFCFTA, gains momentum, and as more Africans migrate for work and education, states will need to accommodate plural, cross-border identities. National sovereignty cannot continue to be weaponized against human dignity. The human faces behind the ruling. Stories of loss, resilience, and hope. Beyond legal doctrines and institutional failures lie the real human stories. Stories of disillusionment, bureaucratic trauma, and a longing for restoration. The ruling in favor of restoring South African citizenship to those who unknowingly lost it due to dual nationality regulations breathes life back into identities that had been erased not by choice, but by statutory ambush. Take the case of Philip Plaatjes, the face of this legal battle. His story, as recounted in the Constitutional Court judgment, reflects not just a legal loss, but a psychological rupture. He was born in Cape Town, raised with deep national pride, and left temporarily to teach abroad. His marriage and subsequent naturalization in the UK were acts of personal evolution, not abandonment of identity. When his South African passport was returned mutilated, corners cut and cancelled stamped across, it symbolized more than a travel restriction. It was, in his own words, one of the saddest days in my life. Philip's experience is far from isolated. Thousands of South Africans, teachers, health workers, engineers, scholars, and humanitarian workers have faced similar fates. They lost citizenship unknowingly when they acquired a second nationality to pursue career opportunities, family reunification, or refuge in volatile times. The decision to acquire another citizenship was often pragmatic, not ideological, and yet the consequences were devastating and lifelong. Some were denied entry into South Africa to attend funerals, to claim family inheritance, or even to bury their parents. Others lost pensions, job offers, or access to property they had bought in their youth. The emotional cost of being labeled a foreigner by your own country of birth is immeasurable. Now, these individuals face the prospect of being made whole, not merely legally, but emotionally and culturally. The court's decision acts as a national apology, acknowledging that South Africa failed to protect the very people who carried its identity beyond its borders. legal ramifications across the continent, setting judicial precedents. This ruling is likely to inspire a wave of constitutional and legal challenges across the African continent, particularly in countries with outdated nationality laws or excessive ministerial discretion in citizenship matters. In Ethiopia, where dual citizenship is not recognized, diaspora Ethiopians often face complications acquiring property, starting businesses, or reclaiming nationality after naturalization elsewhere. In Sierra Leone, although the 2006 Citizenship Amendment Act permits dual nationality, the implementation remains unclear, particularly for those holding public office, highlighted by cases involving diaspora politicians disqualified from elections. Egypt, Morocco, and Rwanda have recently liberalized their citizenship laws to accommodate dual nationals, but judicial review of existing laws remains underutilized as a corrective mechanism. The Constitutional Court of South Africa has thus become a moral and legal compass for other African judiciaries. Its emphasis on procedural fairness, proportionality, and constitutional supremacy sets a benchmark for the continent. African legal systems must now reckon with the fact that nationality laws cannot be divorced from human rights obligations. If replicated or cited across jurisdictions, this ruling could contribute to a continent-wide jurisprudence of inclusion, where citizenship is treated not just as a legal label, but as a safeguard of dignity, identity, and belonging, bridging the gap, statelessness, legal identity, and the African dream. One of the most overlooked risks of automatic citizenship revocation is statelessness, a condition wherein individuals are not recognized as nationals by any country. Although South Africans like Platjes retained their new citizenship, there are countless cases across Africa where people are rendered stateless due to conflicting nationality laws, loss of documentation, or intergenerational legal gaps. Statelessness disproportionately affects children born in exile, nomadic groups, refugees, and those born to cross-national marriages. In Côte d'Ivoire, Kenya, and Zambia, hundreds of thousands of people live without legal identity, unable to access education, healthcare, or political rights. South Africa's ruling signals a pathway toward constitutional protection against statelessness. It suggests that laws must be constructed and interpreted with human consequences in mind, not just sovereignty concerns. Future African constitutional courts can draw from this case to strike down or reinterpret provisions that risk disenfranchising entire communities based on technicalities or administrative opacity. The AU, through its African Commission on Human and People's Rights, must now develop clear guidelines and model laws on the prevention of statelessness, drawing inspiration from this South African case and aligning with international instruments such as the 1954 Convention relating to the status of stateless persons and the 1961 Convention on the reduction of statelessness. Moving forward, national healing, diaspora trust, and policy reconciliation. The Constitutional Court ruling offers a once-in-a-generation chance for national reconciliation between the state and its global citizens, between law and justice, and between identity and mobility. However, restoring lost citizenship is not enough. South Africa must initiate a truth and reconciliation process for diaspora grievances. This may take the form of public apologies and government acknowledgments of harm done, diaspora roundtables and town halls led by the Department of Home Affairs and Civil Society, a comprehensive policy overhaul, including digital identity integration for citizens abroad, engagement with Pan-African and international legal bodies to promote rights-based nationality laws continent-wide. Restoring legal identity must go hand in hand with restoring trust. Without meaningful engagement, the ruling, no matter how historic, risks becoming a hollow victory for many who suffered silently for years. Toward a Continental Citizenship Charter, a strategic opportunity for the African Union. The South African Constitutional Court's judgment arrives at a strategic moment for the African Union, AU, as the organization intensifies its push for deeper regional integration through instruments like the African Continental Free Trade Area, AFCFTA, the Protocol on Free Movement of Persons, and the Agenda 2063 flagship goals. The decision offers both legal precedent and moral impetus for the AU to explore the creation of a Continental Citizenship Charter or framework that harmonizes nationality laws across its 55 member states. Such a charter could serve several transformative purposes. 1. Codify basic principles. Establish a set of baseline principles for citizenship law in Africa, such as prohibition of arbitrary deprivation of nationality, guarantees against statelessness, recognition of dual citizenship, and non discrimination based on origin, gender, or political status. 2. Define rights and protections. Enshrine citizenship as not just a legal status, but as a set of rights and entitlements, including political participation, mobility, access to public services, and legal protection abroad. 3. Provide oversight and redress mechanisms. Establish regional oversight bodies under the African Court on Human and People's Rights and the African Commission to allow individuals and advocacy organizations to challenge citizenship violations across the continent. 4. Foster Pan-African identity position citizenship not as a barrier, but as a bridge for Pan-African solidarity, enabling Africans to carry multiple identities without fear of disenfranchisement. This supports the spirit of the AU Passport Initiative, which aims to eliminate visa requirements for intra-African travel. Such a charter would not eliminate sovereign discretion over nationality, but would require states to exercise that discretion within human rights compliant frameworks. This is increasingly important as migration trends accelerate, diaspora remittances grow, and cross-border families multiply. Actionable recommendations for African governments and lawmakers. In light of the South African ruling and the broader trends toward mobility and integration, African governments must undertake coordinated legal and policy reforms. Here are targeted recommendations for immediate consideration. 1. Legislative review and reform audit all nationality and immigration laws for provisions that allow automatic or discretionary loss of citizenship, especially those that do not require due process or notification. Amend constitutional and statutory texts to explicitly protect against involuntary citizenship loss due to dual nationality or foreign naturalization. 2. Establish transparent dual citizenship frameworks. Clearly outline conditions, rights, and obligations for dual citizens, ensuring that such policies are accessible, equitable, and not subject to unchecked discretion. Remove or reform vague provisions that make it difficult for citizens to know whether or when they may lose their nationality. 3. Engage the diaspora as a development asset. Develop national strategies for diaspora inclusion, leveraging restored citizenship rights to encourage economic investment, knowledge transfer, cultural exchange, and political participation. Guarantee diaspora voting rights, representation, and access to consular services without discrimination based on secondary citizenship. 4. Strengthen institutional capacity, equip ministries of Interior and Foreign Affairs with digital infrastructure to manage citizenship records, provide clear guidelines, and streamline services for citizens abroad. Train consular officials on human rights, nationality law, and the limits of ministerial discretion. 5. Promote continental legal education and harmonization. Encourage law schools, bar associations, and judicial bodies to incorporate comparative citizenship law and constitutional rights jurisprudence into their training and legal doctrine. Foster regional legal symposia and knowledge exchange forums to share experiences, coordinate reform, and build jurisprudential consensus. The road ahead, citizenship in the age of African Renaissance. The Constitutional Court of South Africa has sounded a continental bell of awakening, one that calls for a bold rethinking of how we define, protect, and respect the concept of citizenship in Africa. As we move further into the 21st century, defined by mobility, plural identities, and Pan African interdependence, old laws rooted in fear, control, and suspicion must give way to new legal imaginations anchored in dignity, equality, and belonging. Citizenship can no longer be wielded as a tool of exclusion. It must become a guarantee of connection between individuals and states, between generations and homelands, between past struggles and future aspirations. The South African ruling is more than a judicial victory. It is a vision of what is possible when law is guided by justice and when institutions have the courage to confront their own failings. Diaspora voices, reclaiming identity, rebuilding trust. As news of the Constitutional Court's judgment spread globally, South African diaspora communities responded with a wave of relief, vindication, and cautious optimism. From Johannesburg to London, from Toronto to Perth, individuals who had once been silently stripped of their nationality began sharing their stories, reclaiming their pride, and demanding further action. This ruling is more than a legal correction. It's a moral restoration, said Thandiwe Malangu, a South African nurse in Canada who lost her citizenship after naturalizing for professional reasons. I feel seen again. I feel like my country wants me back. Social media was flooded with messages such as, I am still South African, our citizenship restored, and bring us home, revealing not only a hunger for justice, but also a longing for inclusion. Advocacy groups have called on the South African government to go beyond the court ruling by creating reinstatement clinics, launching digital re-citizenship campaigns, and engaging with embassies to fast-track the restoration process. This moment, therefore, is also a test of political will. Will the South African state seize this opportunity to repair damaged relationships with its diaspora? Or will it allow bureaucracy, indifference, or underfunded institutions to dull the momentum of justice? Post-colonial citizenship and the African youth, a renewed call for reform. As Africa's youth increasingly identify not only by their nationality, but also by their Pan-African values and global citizenship aspirations, governments must adapt to this generational shift. Many young Africans study, work, and innovate across borders. Denying or revoking citizenship because of global exposure is a step backward in an era that demands transnational cooperation and shared identity. The youth-led movements across Senegal, Nigeria, Sudan, and South Africa have made it clear that this generation demands rights-based governance. Citizenship lies at the heart of this demand. It is the passport to voice, to justice, and to political participation. By aligning nationality laws with post-colonial ideals of freedom, agency, and mobility, African governments can build states that are not only sovereign, but legitimately inclusive, capable of uniting diverse peoples in pursuit of collective progress. Final advice to African leaders. In light of the South African Constitutional Court's ruling, African leaders must take bold, deliberate, and principled steps to modernize their citizenship laws and practices. The following 5 points serve as a framework for action. 1. Anchor citizenship in human rights and constitutional supremacy. Avoid arbitrary revocation of citizenship and ensure that all nationality decisions are subject to due process, legal safeguards, and judicial oversight. 2. Embrace the diaspora as a strategic partner, not a threat. Recognize dual nationals as assets for development, diplomacy, and national reputation, not as divided or disloyal. 3. Develop clear, transparent dual citizenship policies. Remove ambiguity, streamline application procedures, and eliminate unnecessary barriers to holding multiple nationalities. 4. Ratify and domesticate the AU Free Movement Protocol, show continental leadership by facilitating lawful mobility, regional solidarity, and the economic benefits of integration. 5. Champion a Continental Citizenship Charter, work through the African Union to create a binding legal instrument that protects nationality rights across Africa, reduces statelessness, and affirms Africa's commitment to dignity and unity. Summary of key messages. The South African Constitutional Court's ruling declaring automatic citizenship loss for dual nationals unconstitutional is a historic milestone in African constitutional law and human rights jurisprudence. The case, centered on Philip Plaatjes, reveals the human and emotional toll of bureaucratic disenfranchisement. This decision has far-reaching implications, not only for South Africa's diaspora, but also for other African states with restrictive or outdated nationality laws. It sets a judicial precedent that upholds the primacy of constitutional rights over ministerial discretion, especially in matters affecting identity and belonging. The judgment provides a template for Pan-African reform, urging the African Union and member states to work toward legal harmonization, diaspora inclusion, and youth-responsive policies. To fully realize the potential of this ruling, African governments must now match judicial courage with political leadership, ensuring that citizenship is a gateway to inclusion, not a tool of exclusion. Thank you for watching The Bold African Voice, BAV. If you believe citizenship should empower, not exclude, hit that like button, drop your thoughts in the comments, and share this video to amplify awareness. Don't forget to subscribe and click the notification bell so you never miss our bold takes on Africa's evolving landscape. Until next time, stay informed, stay engaged, and stay bold, because together we are the bold African voice.